Well, it's 4 o'clock. It's our sorry for the change in the Zoom meetings from Monday to Tuesday, but I have additional responsibilities that came up that precluded me from continuing to have that 4 o'clock meeting on Monday. So I moved it to Tuesday. The This week we have 2 chapters rather than 1. I have to admit that your you guys have performed very well up to this point in time regarding the assignments. You guys are handling it very well, and you're kind of knocking them out of the park, and that's very good. And keep up the good work. You're doing a great job. The chapter 9 is actually an extension of the chapter 6 on contracts, and it goes into a little further about some things. Now, if you remember, a meeting of the minds, which was the genuine assent in the second of 6 requirements necessary for the enforceable contract in the previous chapter, genuineness of an assent to a contract is present when there's evidence of a true meeting of the minds of the parties to the agreement. The defective agreements happen if there are no misunderstandings, use of force, or deception to obtain agreement by either party, the contract is voidable. If there are misunderstandings, use of force, or deception, the contract is voidable. That is, may be disaffirmed at the option of the injured party. If someone considers themselves to be injured, then they have the ability to disaffirm themselves, and it becomes avoidable. A voidable contract results if agreement of either party is obtained by fraud, misrepresentation, mistake, undue influence, or duress. A voidable contract may result if the contract is one of adhesion or is unconscionable. Intentional misstatements or disclosures of material fact made by one party to influence the actions of another party is fraud. Fraud may arise from spoken or written words or by acts or conduct. Fraudulent misrepresentation arises when the party who relies on the misstatements or non-disclosures suffers a loss or damages from the act. Intentional concealment or non-disclosure of the material facts is just as fraudulent as making a false statement. In order to prove a case of fraud, a plaintiff must demonstrate 5 elements: a misstatement or non-disclosure of a material fact, knowledge of its falsity and or with reckless disregard of its truth, intention of causing the other party to enter into the agreement, reliance by the injured party, and harm to the injured party, financially, physically, or both. Now, we've all seen this. There is a distinct difference between fraudulent statements and a salesperson's puffing. Puffing is considered a mere expression of opinion, usually exaggerated. Most of us have experienced this when we've heard examples such as the washing machine is the best in town, or this computer is as good as other well-known brands. The engine in this car has the latest hybrid technology. These are some of the things we all, I'm sure, along the way have had experience with it. Now, negligent misrepresentation is an unintentional misstatement or non-disclosure of a material fact that results in inducing another to enter into an agreement to his or her loss. Remedy is different from fraud. An injured party proving fraud may have contract canceled or sue for additional damages. An injured party proving misrepresentation may have the contract canceled, but normally cannot sue for additional damages. Now, a mistake is an act that is not in accord with the facts. Mistakes related to contracts may concern the nature of the subject matter or quality of the subject matter. Courts' decisions involving mistakes are sometimes complex, and courts attempt to determine whether the mistake was either unilateral or mutual. A unilateral mistake is a mistake made by only one party. This can blur the misrepresentation, and it depends on the circumstance. A mutual mistake is a mistake made by both parties. For a contract to be dissolved due to a mistake, the law usually requires both parties to be part of the mistake. Example, Chin, a painter dealer, offering to sell a particular Picasso painting to Kovacs for $14,000. When it came time to exchange the painting for the money, it was obvious that Kovacs expected a different Picasso painting. He wanted catalog number 1410. Chin believed Kovacs wanted to buy the one in 1401. The contract can be canceled by either party because this was a mutual mistake. Undue influence. At times, a person may have power to control actions of another due to special or confidential relationships. When a person uses such power improperly to their personal advantage, it is undue influence. A contract resulting from use of undue influence is voidable at the option of the wrongfully influenced party. Good examples of this are relations between an employer and employee, physician or nurse and patient, teacher or student. Duress is an act of applying unlawful or improper pressure or influence to a person in order to gain their agreement to a contract. Some types of pressures are threat of bodily harm to you, your family, or your personal reputation, defamation to you, threat or serious loss of damage to property. If someone enters into a contract under duress, the injured party may void the agreement. Contracts of adhesion, a contract that involves parties who have unequal bargaining power, known as take it or leave it contracts, which we've all been involved with from time to time. These contracts, though common, are normally enforceable. But when enforcement of an otherwise legal contract results in a significant hardship to one of the parties, courts do consider such agreements unfair and unenforceable. Inequality of bargaining power exists in contracts prepared by one party and presented to the other without opportunity for true negotiation. Loren bought shirts to a laundry, wanting them clean. A note on the receipt was given indicated that the establishment was not responsible for goods left over 30 days. Lorenz attempted to pick up these shirts 35 days later and was told that under the contract, he was not entitled to them. The 30-day clause would be a contract of adhesion. Unconscionable contracts is regarded as shockingly unjust or unfair as to offend the public. While courts are reluctant to uphold such contracts, recently the UCC, the Uniform Commercial Code, has made unconscionable contracts much less likely to be enforced. Many states now have laws with criminal penalties against unconscionable contracts forced on the elderly. Under the UCC, there is a judicial finding of unconscionability. The court may refuse to enforce the contract or strike any unconscionable clauses and enforce the remainder of the contract or limit application of the unconscionable clause to avoid any unconscionable result. So that's it, pretty clear their relationship, the type of things that can happen when you're involved with contracts relation to this. So the process becomes extremely important in relationship to how you proceed with a contract to make sure, one, that you avoid all of these requirements that would end up voiding the contract. We'll now go into chapter 17, which is the second one. And this is lengthy, so bear with us. It'll be some minutes. And we'll go, and this one is about sales. And we all know the process of sales is limited to certain actions regarding and how you proceed. Law of sales affects many individuals and business and is very comprehensive. It does not include investment securities, real estate, or services. Contracts for services are considered ordinary contracts and are not covered under the UCC. In transactions involving both goods and services, a court looks to the predominant portion of the contract to determine whether it is a sales contract for goods or for services. So depending on what the majority of the contract is for, will determine whether or not it will be considered an ordinary contract. Contract for sale, legally enforceable agreement whose purpose is immediate transfer of title to personal property in return for consideration, may be for the present sale of goods or the sale of future goods. Sale is passing the title from seller to buyer for a price. Payment may be in the form of money or other goods. They can either be existing goods, goods that physically exist that are owned by the seller at the time of the sale, or future goods, goods that do not exist at the time of the sales transaction, but are expected to come into possession of the seller. Example, crops that are being grown, or timber is going to be needed to be cut, or goods that are not yet harvested or manufactured. Agreement to sell future goods is considered a contract to sell in contract to a contract for sale. The distinction between the existing and the future goods is important because a person cannot sell goods to which they do not hold title. In almost every case, courts have held up title to future goods remains with the seller. Sales contracts may be oral or written, expressed or implied, as described in the section on contracts. Contracts greater than $500 must be in writing to be enforceable. The complete agreement need not be in writing, but should have evidence intent of the parties, and the contract must be signed by the parties. Now, the difference between entire contracts and divisible contracts is distinct and may be seen in many transactions done. Entire contract is all of the components are interdependent and included in the same order. Payment for contract would not be required until the whole order is fulfilled. Divisible contract, the components are ordered as separate entities. Payment for each deliverable is due when delivery is complete. Contracts for labor and materials, sales contracts for goods, special design, construction, or manufacturing is neither a contract for sale nor a contract to sell. Contract for labor and materials does not have to be in writing to be enforceable, even if it's greater than $500. Contract will not be binding if buyer cancels the oil contract and seller receives notice before the seller made either a substantial start in the manufacturing goods or commitment for the materials. If the seller has begun manufacturing and made commitment, cancellation is not effective. Trial periods and returns. Some sellers are willing to allow prospective customers a trial period or a right to return for merchandise. We've seen these on a lot of commercials and advertisements. It's important to determine who owns the title of the merchandise while the prospective buyer has possession in event of loss or damage. An online store sends a customer a vacuum cleaner to try for 30 days because the customer makes it before he makes a decision to buy it. Contract for sale with right to return. Sometimes goods are sold on a trial basis. A short trial period will be established during which the buyer can use the goods. Contract for sale with the right to return gives the buyer both title to and the goods and an opportunity to return them to the seller at a later time. Sale of approval is when a contract provides for sale of goods subject to the buyer's approval. The transaction is a sale on approval. Goods remain property of the seller until the buyer has confirmed approval of the goods. Sale or return. Most goods sold may be returned for a variety of reasons unless the sale is clearly identified as final or circumstances of return are unreasonable. Sale or return, an agreement where the seller will accept return of the goods at the request of the buyer. Merchants will agree to sell or return to a sale or return in order to maintain goodwill rather than insist on the fact that the seller is legally obliged to accept the return of the goods. Other kinds of sales, auction sales. A buyer, the party making an offer to bid. The seller is the owner of the goods, engages an auctioneer to get bids from interested parties with intent of selling to the highest bidder. A bidder may retract the bid at any time before the hammer falls, and such transaction does not revive any previous bids. Kinds of auctions. Auctions without reserves. Goods must be sold to the highest bidder and may not be withdrawn after the bidding has begun. Auction with reserve gives auctioneer right to withdraw the goods at any time before announcing completion of the sale, if bids are not made at or above the reserved amount of the seller. If the reserve amount has been established, it is announced by the auctioneer before the bidding starts. Auction sales are usually reserved unless otherwise identified. Other kinds of sales, conditional sales. A way of selling merchandise is with the condition that the title will remain with the seller until purchase price has been paid. Buyer cannot legally resell the goods purchased this way as title has not been passed. A person cannot legally sell the goods to which they lack the title. Seller may repossess the goods if the buyer does not pay in the time agreed. Other kinds of sales, consignment sales. Some of you may have done this from time to time. It occurs when a seller entrusts goods to a merchant at a consignment store. Merchant acts under contract as the seller's agent to sell goods in exchange for a fee. Now let's talk about delivery. Many transactions require shipments of the goods purchased, but shipping goods is not without risk. Goods that are in transit have risk that damage may occur. Example, flooding, accident, fire, etc. Generally, a prudent party will make sure certain goods are insured against loss, but to do so, they must have an insurable interest in the goods. Insurable interest. Insurable interest is the right to insure goods against potential loss. Sellers have an insurable interest in goods as long as they have title. Buyers are allowed to insure goods even before they obtain the title, if they choose to. Delivery. The manner in which goods are shipped affects passing of the title. Titles to goods shipped by private carrier or delivered by the seller passes at the time of delivery to buyer. If the buyer arranges for delivery, titles pass when the buyer or his or her agent picks up the goods. If goods are shipped by common carrier, title passes to the purchaser according to the following conditions. FOB means free on board. FOB shipping point, the title to goods passes from seller to buyer. When the carrier receives the shipment, buyer pays the transportation charges. FOB destination, title passes when goods are delivered to the buyer. Cost of the goods is paid by the carrier to the carrier by the seller, but usually included in the buyer's invoice. Buyers have an advantage when they do this method of shipment. Remedies for breach of sales. Remedies are available for a limited time. The UCC provides a statute of limitation, a time limit after which usually legal remediations are no longer available. In absence of negligence or frauds, legal action for a breach of contract sales must start within 4 years from the breach. Seller's remedies. Buyers refusing to accept delivery of goods. Store goods for buyer. and sue to recover sales price. Resell the goods immediately if perishable or if the market value might be depreciating. Seller may sue buyer for difference between the price of the goods bought in the resale and the price the buyer agreed to pay. Retain the goods and sue the buyer for difference between the contract price and the market. Buyer refuses to pay the purchase price. If the seller still has possession of the goods, the seller may resell them. If the merchandise has already been delivered to the buyer, seller may sue for the purchase price. Example, Kip placed an order with best purchase for specially designed medical testing equipment. When the equipment was ready for shipment, Kip notified Best Purchase for its intention to cancel the order. When the buyer refuses to accept the delivery of goods, the seller may retain the goods and sue the buyer for the difference between the contract price and the market price at the time the buyer refused to honor the contract. In this case, Best Purchase has the right to hold the equipment for Kip and sue for the agreed upon purchase price. Seller's remedies. When a buyer is insolvent. When a buyer is insolvent, the seller has the right of stopping the goods in transit. Stopping in transit is the right of an unpaid seller to stop goods in transit and order carried to hold them, and orders to carry to hold them. This right exists both for FOP shipping point of sales and FOP destination sales. Buyer's remedies. When wrong quantity is delivered. If a smaller quantity is delivered than ordered, the buyer may reject the entire delivery and sue for damages, or accept the quantity delivered and sue for damage. If a larger quantity of goods is delivered than ordered, the buyer may reject the entire shipment, accept only what was ordered and reject the rest, or accept the entire shipment and pay additional items at the contract price. When the goods are not as ordered, buyer may revoke the contract and return the goods substantially different from those orders. If the goods have already been paid for, the buyer may demand a refund of the purchase price. Buyer's remedies. When the seller fails to deliver the goods, a buyer may sue for damages by bringing action charging conversion. If the goods are unique and the buyer wants particular goods specified in a contract, the buyer may seek a court order of specific performance. A buyer who wishes to obtain goods that are rightfully theirs rather than money down may sue to obtain them by bringing an action to replevin, an action to recover personal property to be built or claim to be unlawfully taken. A buyer may recover if he chooses to cover. The buyer may demand from the seller as damages differences between the cost of the cover and the contract price. If title is not yet passed to the buyer's remedy when seller refuses to deliver the time and place stated in the contract is a sue for breach of contract. Buyer's remedy example. Terry ordered 100 microwave ovens from the wholesaler, but the wholesaler made an error and shipped 200 microwaves. But Terry was delighted he received an unexpected bargain since the price of the microwave was going to increase shortly as a result in the change of the foreign exchange rate. If the seller delivered a larger quantity of goods that were ordered, the buyer may reject the entire shipment, accept only what was ordered, or accept the entire shipment and pay for the additional items at the contract price. In this case, Terry can take delivery of the entire shipment and pay for all 200 microwaves at the contract price. So that's chapters 9 and 17. We have one more chapter, chapter 20, before we do the next chapter test. Have a good week, and I will be back again next Tuesday. Take care. Bye.